Huh? Yeah, she's way ahead of me. Good evening, everyone. It's been a long day, I can see. All right, This is a code enforcement hearing for the city of North Miami. Today is July 1st, 2015, and I am Beatrice Cazo, Special Magistrate for the city of North Miami. The purpose of this hearing is to determine if a code violation exists at your property as observed and cited by a code enforcement officer of this city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded. Therefore, all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case. We have a translator who will assist you during the proceedings. When your case is called, the property owner, agent for the property owner, and any witness that you may have should come forward to the podium on the left side of the room. When asked, please speak directly into the microphone and say aloud your name, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware of and understand the violation that is being heard today. And do you understand what is required to resolve the violation? Please answer accordingly. The city will present its case first, and then the property owner or violator will be given an opportunity to testify on their own behalf, to bring forward witnesses to testify, to present evidence and photographs, and to cross-examine the city's witnesses. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending on the case type, I will set an abatement date for the violation to be resolved. Or, for repeat violations, I will impose a daily fine amount. For new, non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing date should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table this case proceeding to another hearing date in the future. If you do not agree with my finding of fact and or ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida statutes, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record of the proceeding. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at this proceedings. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. Now, if anyone present who will be given testimony, please rise and raise your right hand so the officer can administer the oath.
If you're about to give testimony, please rise. Raise your right hand. Do you swear and solemnly swear that all the facts that you're about to state are true and accurate, put your telephones on silent, and if you should have to respond to a call, please step out the back door, take it, and call in. Thank you, Ms. Stevens. Please. Go ahead, Ms.
Please announce if we have any additions, corrections, and/or deletions to the hearing agenda, please.
Item number 3, case number CEWRA 2015-00104, complied. Item number 4, CEXP 2015-00015, complied. Item number 8, CEODS 2015-00035, complied. Item number 9, CEBPR 2015-00021, postponed a month. Item number 10, CEIVY 2015-00033, complied. Item number 11, CEJNK 2015-00085, complied. Item number 12, CEMHO 2015-0022, postponed a month. Item number 15, CEBMP 2015-00012, postponed a month. Item number 17, CEEXP 2015-00178, postponed a month. Item number 18, CEEXC 2015-00014, complied. Item number 19, CEXP 2015-00185, complied. Item number 21, CEEXP 2015-00091, complied. Item number 23, CEXP 2015-00004, complied. Item number 24, CEXP 2015-0025, complied. Item number 25, CEJNK 2015-00016, complied. Item number 26, CEPOD 2015-00005, complied. Item number 27, CEFAW 2015-00031, postponed a month. Item number 28, CEMHO 2015-00025, complied. Item number 29, CENUS 2015-00009, complied. Item number 30, CEXP 2015-00104, complied. Item number 31, CEXP 2015-00103, postponed a month. Item number 33, CEFAW 2015-00066, postponed a month. Item number 35, CEIVY 2015-00042, complied. Item number 40, CEIVY 2015-00050, complied. Item number 41, CEEXP 2014-00325, postponed a month. Item number 43, CEEXP 2015-00192, postponed a month. Item number 44, CEBPR 2015-00014, complied. Item number 45, CEODS 2015-00185, complied. Item number 46, CEXP 2015-00151, complied. Item number 47, CEWRA 2015-00094, complied. Item number 49, CEXP 2015-00234, complied. Item number CEIVY 2015-00044, complied. Item number 54, CEXP 2014-00244, complied. Item number 55, CEODS 2015-00073, complied. Item number 56, CEXP 2015-00119, complied. Item number 57, CEFAW 2015-00039, complied. Item number 58, CEXP 2014-00336, complied. Item number 60, CEBLR 2015-00031, complied. Item number 62, CEJNK 2015-00030, complied. Item number 65, CESEA 2015-00003, postponed a month. Item number 66, CEBPR 2015-00041, postponed a month. Item number 72, CEFAW 2015-00061, complied. Item number 73, CEJNK 2015-00017, complied. Item number 77, CEJNK 2015-00014, complied. Item number 78, CJNK 2015-0007 complied. Item number 79, CEIVY 2015-0068 complied. Item number 80, CEIVY 2015-0047. And that completes all the deletions on the agenda.
All right, if we're ready, please call the first case.
First case, Betty Walker. Case number CEBNP 2014-00121. Officer Edmund Fitzel. Item agenda number 5.
Did you say 5? Good evening.
Good evening.
Please state your full name for the
My
record.
name is Carolina Leyva. I am here on behalf of Betty Walker.
All right. Did you give your power of attorney?
I am an attorney.
Oh, okay. Can I get your name again?
Yes, Carolina Leyva.
Edmund Fitzel, City of North Miami Code Enforcement Officer. This case was already adjudicated. It was pushed back 1 month as of last month, if you recall, as Ms. Walker attained attorney. As of today, there still has no permit has been pulled for the shed. The property was posted with notice to appear on June 19th, and notice to appear was mailed out.
Okay. Do we have any photographs? Because I can't remember.
There's no photographs. It's just a photograph of a shed that needs a permit. And as of, this has been going on for it's been going on for almost 10 months now, and there still is no permit that has been pulled. As of last month, a few months ago, they went to the building department, and it was denied from the Florida Building Code. Needed straps, needed several different things from the building department that they weren't happy with. So last month was set for a fine, but at the last moment, they had an attorney came and presided in front of you, and you gave them 1 more month to get their permit.
All right. I guess 1 month is a very long time because I don't remember. So where are we on this? What's going on?
Well, as I understand, there was a permit submitted, and there was approval actually given at one point in May 13th, 2015, and then suddenly there was a notification of denial. My client has lived on this property for over 20 years. The shed was on the property when she moved in. There's purported issues with the installation of a shed, which, as I understand it, is not the case. But beyond that, I know that the architect and the general contractors have been diligently working to prepare the corrections or added information that remained outstanding. And as I understand it, I've been advised by my client, those documents should be prepared and submitted within the next few days, considering it's a long weekend, give or take, but within the next few days, certainly.
Okay. Officer, that's all?
I mean, this has been going on for some time. I noticed it was tabled back in February for March, and then back again from March to July. And then last month it was a finding of guilty back in January.
I noticed.
Yeah, this new computer system, it's you gotta go back and forth. I have no problem giving them another 30 days. It's been going on for so long. I mean,
All right. This would be our final attempt because this has been going on for quite some time. This matter, since actually November 2014, it was adjudicated back in January, and I do see that it was tabled quite a few times. And so I'm gonna reset it 30 days. Please get it done, otherwise I'm gonna have to ratify. And then it would act retroactively, so she would owe a pretty penny, okay?
Thank you.
Thank you.
The next case is item number 32, Harold Toussaint. Officer Wayne Clark, case number CEIVY 2015-000053, item number 32.
My name Toussaint Harold. The address 1210 Northwest 121 Street, North Miami, Florida. Okay, vale. No. Harold Toussaint.
Harold Toussaint,
Mhm.
The address 1210 Northwest.
1210 Northwest 121st Street, North Miami, Florida 33167.
All right.
Wayne Clark City, North Miami Code Compliance with North Miami Police Department. This case is in reference to an inoperable vehicle on the property. There's a white pickup truck in the driveway that has flat tires on it and no tag on it. And this is the first time I've seen the gentleman today. I have proper service. On November 21st, 2015, the property was posted. And let it be known on the record that the property is homesteaded. And to date, the vehicle still remains the same. Pictures with a date of June 29th, 2015, which was yesterday, displays that the car's in the same position. I mean, same condition, excuse me, and I would like to submit the photos for the record, first showing the defendant.
Yeah.
Yes. I'm sorry. Est-ce que le même état? Même genre? Les deux sont
We
dans la
can't
cour?
hear.
Dans la cour?
Oui, dans la cour, dans la yard, moi.
Yes, it's in my yard.
All right, Mr. Toussaint, this is your vehicle?
Oui.
Yes.
All right. It has a flat tire.
Oui, con caoutchouc flat là-dedans.
Yes, it has a flat tire.
Okay. Does it have a tag? Is there? It doesn't have a tag?
No tag, as displayed on the photo on
Okay.
the rear bumper where it attaches.
All right, sir, what is your intention? What do you intend to do with this vehicle?
Le véhicule là, son panne moteur, gain, son moteur, m'a voulu mettre là-dedans, c'est ça que fait me baguer.
It has a problem. The motor has a problem. I'm gonna put a new motor. That's why it's still there.
Okay, I asked him just to fix the flat tire for now.
Hmm?
I asked him if he could just fix the flat tire for now. It would have been taken care of, but he did not contact me.
Oui, ça me qu'a fait.
Yes, that I can do.
All right, so that would satisfy the,
Yes, for me, yes.
okay. So, sir,
Monsieur,
please
tant pis.
fix the flat tire,
Changer caoutchouc plat là.
okay? And inform the
Okay.
officer once it's
Dire
done.
que si alors fin fait ça, attendez.
Okay, so I will reset it 30 days and you can take it off calendar if it's done.
Et puis si vous
Okay.
faites, n'a pas
Huh?
de
I agree.
calendrier.
All right,
Ça y va, moi, tant pis, qu'a fait, dans son bail, qu'a fait dans ce qu'un, ça veut dire, bah, je me recevoir rien.
This can happen in a second. I don't need a month. I never got anything.
okay, just
What
fix
is
it.
that?
Ok, monsieur, merci beaucoup. Passez là, attendez.
Ok,
Pas
Yeah.
besoin de caoutchouc.
ok, merci.
All right, thank you, sir.
Non, pas de problème, nous qu'a arrangé. Yeah, ok, merci beaucoup.
Before we proceed, I just want to announce Walter Miller. Anybody here for the case Walter Miller?
Can't hear.
Walter Miller?
Is Walter Miller present?
Okay, well, never mind. Okay, next.
I think Officer Christie's trying to tell you something. Crystal?
They left? Okay, thank you. The next case would be item number 71, Vecino Del Mar Sales Corp., Officer Vanessa Willis, case number MHZCU 2014-00001, item number 71.
Good evening, sir. Please state your full name and your relationship to the property for the record.
Yes. Frederick Spiegel. I'm the president of Vecino Del Mar Sales Corp. And the principal in the company. I'm a Florida licensed attorney. I'm a registered real estate broker. I'm a general contractor. And I've been in the development business for about 40 years. I'm authorized to write title insurance, and I would like to be recognized as an expert in Florida law, condominium law in particular, as I have worked in the field of condominium law for the last 30 years.
Okay. You wear a lot of hats, many hats?
Yes, ma'am, and to be honest with you, with all due respect to your honor, and I do respect you, I'm very upset with what's going on with this situation. And I would like to, I don't want to waste these other people's time or take a lot of your time.
Okay. Just so you know, I'm not familiar with the facts of the case yet.
Yeah,
Do you
no, I
want
understand that, Your
give me an
Honor.
opportunity to hear what the city has
Okay.
to say, and then I will give you, you know,
Okay.
the opportunity to respond.
May I
Okay,
make
let me
just an
just-
opening statement?
Sure?
With all due respect to your honor and your position, and this is not a reflection on you because I don't know you, I believe that what the city of North Miami is doing with regard to their code enforcement magistrates is not in compliance with Florida law, Chapter 162, nor is it in compliance with their own ordinances. The ordinance requires that any individual to be appointed to your position must be either a retired judge, an attorney, but it has one additional conjunctive requirement. You must be involved with municipal law. Now, I looked at your CV online, and I'm aware that you do divorce work, I believe, and I don't think that that complies with the intent. The other problem I have, and it's not with you or necessarily with the city of North Miami, but the Florida legislature, and I was on the City of Miami Beach Code Enforcement Board for a long time, and at that time they had citizen boards. And the intent of the original statute was to have a diverse group of citizens that lived in the community that would hear other citizens' violations and could bring to the table 6 or 7 professional or business areas of expertise. Now they've reduced this to a singular hearing officer, and the city of North Miami has further restricted it beyond the scope of Florida Statute 162. I believe Your Honor will give me a full and fair hearing here tonight, but I'm very uncomfortable with the concept of a hearing officer that is solicited by the city, interviewed by the city, hired by the city, paid by the city, and I believe there are other defects in what the city of North Miami has done in that they have a restrictive 1-year contract that can be canceled at any time for any reason without cause. And all of those are contrary to the intent of Florida Statute 162 because it doesn't assure an individual becoming before an individual hearing officer that they can get a full and fair hearing. Anyway, that's my statement. Based upon that, I would respectfully, most respectfully request that this matter be quashed, dismissed, and terminated immediately, based upon the fact that I don't believe there is jurisdiction on the part of the this tribunal to try this matter. Thank you, Your Honor.
Thank you, sir. I've heard your statement, but I will proceed accordingly. I'm going to give the city officer an opportunity to present her case, and then I promise you that I will be fair and impartial, and I understand you think that just because the city signs my check, I cannot be fair and impartial.
No, Your
and-
Honor.
Okay.
No, I don't believe that you are not fair and impartial. I believe that you are a decent, honest, fair magistrate and a good lawyer. But I believe that what they're doing, because of the fact that they have created this tribunal, which has the authority to make major fines and take away major property rights and interests of individuals and companies.
And I'm sure you're also aware that if you disagree with my ruling, that you can file an appeal.
Yeah, the
Okay.
other problem with that, Your Honor, is, and this is, none of this is directed at Your Honor,
I'm not taking this personally at all.
because I don't want to offend you. I respect you.
I'm not taking this
But from
personally
a
at
technical
all.
perspective, I'm trying to set up that if I have to take this on appeal, the problem with the appellate process is they don't hear the case in the appellate court de novo. It comes to the appellate court based upon trying to overturn any findings of fact that the hearing officer or the magistrate could make, and it basically puts an individual who wants to seek an appellate remedy at a tremendous disadvantage. And that's why I wanted to reiterate my points on the record, because technically, I believe that there are violations of 162, and that's why I did that. Not to offend Your Honor and not to in any way impinge your integrity.
All right, no offense taken.
Vanessa Willis, City of North Miami, Code Enforcement Department. The violation is for failing to obtain a certificate of use and business tax receipt for the business known as Vecino Del Mar Sales Corp. I found out via a complaint, I received a complaint at the condo association that there was a laundry room that was being operated. However, it was not being operated by the condo association, and so therefore I checked, and there was no business tax receipt, and there was no certificate of use issued by the City of North Miami, and the violation was issued. For tonight's hearing, as far as service is concerned, I did post the notice to appear at the property on June 22nd, 2015. I have photos and an affidavit of service, as well as the notice being sent, certified mail, and a copy posted at City Hall on June 18th.
All right. Do we have any photographs? Do we have anything?
All I have as far as photographs, because at the time of the re-inspection, the laundry rooms were closed. So I have the notice where it says out of service until further notice. For alternative options, please refer to the list of nearby laundromats, Coin Laundry shown below. And then there's a notice, so I'm going to pass this to Mr. Spiegel and then to you. And I also have a witness who lives in the building whenever Your Honor would like to hear her.
Okay, just so I'm clear, this is a condominium?
Yes, ma'am.
All right, and how many laundry rooms are we talking about?
There, well, the tenant is saying, or the owner inside the condo association
I
behind
would
me is saying 27.
Your Honor, with all due
I have-
respect, if they have witnesses that are going to, I beg your pardon? Okay, I'm just objecting to the hearsay evidence coming in. If they want to testify as to what they have personal knowledge of, I have no problem. But if they're going to quote other people, I'd prefer to have an opportunity to cross-examine them. And that's basic constitutional law
They-
that
all
gives me a right to a full and fair hearing.
All right,
As I was stating, there are several laundry rooms throughout the building. They're on every floor. Well, they're on several floors. I haven't gone to each and every floor, but they're probably on every floor inside the condo association, minus the lobby area. So I'm gonna show him the photo.
Your Honor, may I respond to the,
Well, before that.
I would object to the photograph coming into evidence because it doesn't have anything to do with what the claimed certificate of use is. They have no idea who posted the notice. As you'll hear in my testimony, I have no idea who posted the notice, and I have no control over that.
All right, it doesn't really tell me anything. I just see an out-of-service notice. And I
Madam-
think the city attorney had questions.
Yeah, I just had one for Officer Willis for clarification. The laundry facilities, are they of the type that are provided as a supplied amenity to the residents of the condominium association, or is it in fact one that is for charge for a business?
It is for charge. There are little slots where you would put your money inside. I've been in them before, but it just so happened that when I went there for the re-inspection, all the doors were locked, so I had no access.
Okay, but they are not free of charge?
They are
It is
not
not
free.
a supplied amenity on behalf of the condo association?
No.
Thank you.
You're welcome.
All right. Mr. Spiegel, do you have any questions for the officer?
Yes, I do. What is your, for how long have you been a code enforcement officer?
I started working as a code enforcement officer, ironically, in the city of Miami Beach, in the city of Miami Beach, in 1995. I've been with this city for 8 years.
And have you had special training for being a code enforcement officer?
Could you specify what is special training?
Have you gone to a training school to be
I have gone
certified?
to code enforcement.
What's the relevance of this question?
Well, if the officer's going to testify as to things, I have a right to have some idea as to what her experience and education is. Okay.
Overrule. Let's get to
Okay.
what we're here for, because
Okay.
we do have a long calendar.
Yes.
Let's get to the business at
Do
hand.
you know how old the building is? The Vecino Del Mar condominium, correct?
Yes.
Do you know how old the building is?
No, I don't. I do have the property, the Miami-Dade property appraisers page for the building, but I do not have, I don't have an idea of how old the building is. I know it's over 40 years.
Over 40 years.
Mhm.
Do you know how long the laundry rooms have been in the building?
I do not.
So you don't know if the building has originally had those laundry rooms?
I do not.
Do you know anything about Florida condominium law?
Some things, yes, I do
Okay.
know.
Who's required to maintain the laundry rooms? Do you know that?
Well, every condo has different rules and regulations. I spoke with the property manager, Affinity
Okay,
Management.
I don't want you to tell me what
Okay,
third
but
parties told
he
you.
told me that you were responsible for these machines.
Okay. Who is responsible to maintain the common elements of a condominium in the state of Florida?
In the state of Florida, I cannot give you an answer to that question.
Pursuant to do you know when the condominium documents were filed on the building?
No, I do not.
Okay, so you wouldn't know who is responsible per the condominium documents to maintain the laundry rooms?
I have not looked at the condo association's documents. However, I was told by the
Okay,
management.
I'm going to object
I
to your...
was told by the management that you are responsible. That's why I
Okay.
cited you.
Okay, I'm going to object to your statement. I'm going to move to strike because it's hearsay. Have you ever threatened
Go ahead.
me?
Just a second, please.
Your Honor, we would respond to the hearsay statement. It's not hearsay if it's a first-person communication conversation that the code enforcement officer had. It isn't. I mean, she's testifying as to her conversation. She's not testifying as to another person's conversation.
Well, she's testifying to a conversation that she had with a third party regarding Mr. Spiegel. I'll allow some level of hearsay, but I'll weigh the evidence on
Thank
both
you.
sides.
Well, it's difficult for me to cross-examine a person who's not here that makes statements that I know to be totally incorrect.
We have a representative from the one of the owners inside the condo.
I will
So-
hear, I will hear from
Okay.
your witnesses afterwards. I will give Mr. Spiegel an opportunity to cross-examine.
Okay.
Did you ever threaten me or anybody else with the police?
No.
Did you ever send an email stating that although it's short notice, you have to appear tomorrow morning
No.
to meet the police?
No.
Give me one moment, Your Honor. Too many papers. Counselor, you want to take a look at this? I'd like to put it in evidence. Is this an email that you sent? All right, let me go ahead and have it.
I'm reading it. Give me one moment, please.
Well, let me have it marked so you
Oh, okay. Sure.
Exhibit 1. Whatever you want. Showing the witness Exhibit 1.
May I speak on this? Or you want to see it first?
I don't think
Okay.
he's asked you,
Okay.
did you ask the question of the document?
Is that an email that you sent with regard to the police coming to see me or me wanting to go to the police?
You can read it into record. It was not a threat. It is an email, and it was not to you. It was to Mr. Reyes, as it is addressed to Mr. Reyes.
But wasn't it intended to be forwarded to me? To meet you tomorrow, that next morning at 8 a.m. because the police wanted to meet with me.
Can you repeat the question? Can you repeat the question, Mr. Spiegel?
Didn't you send this email to be forwarded to me to tell me that the police wanted to meet with me the next morning at 8 a.m.?
The email says, "Good morning, Mr. Reyes. Per our phone conversation this morning regarding the complaints the building department has received from one of the condo owners, I am sending the following request for dissemination. I apologize for the late notice. However, the request was sent Saturday and I received it this morning. The police department is requesting a meeting tomorrow morning at 8 a.m. with you and the following people: Frederick Spiegel, Elton Carner, and the laundry room mechanic. Thank you in advance." This is dated September 29, 2014, and it was sent, that was a Monday, and it was at 8:48 a.m. I didn't remember about this particular email, but in my defense, I am supervised by the police commander, Commander Blanchard, and whenever they send a directive to meet someone at a building regarding a complaint, I will either call them or email them. I think that Mr. Reyes must have asked me to send something.
I'm going to object to her
To send something.
summarizing what a third party has said.
All right. Without telling me
Mhm.
what your conversation was with whomever,
Okay.
just answer Mr. Spiegel's.
Okay, well, I just
question.
read this, so there's his answer right there. Yes, I did send this email according to what this is. I don't know if it has been tampered with, added to, taken away from. If I could go in my archives on my computer to see if this is exactly what I sent him, then I could answer this question honestly, but I don't remember. I don't remember if this was the full contents. As we know, we can always forward something to someone. They can take out what they want to take out and add what they want to add. So if he was going to put this into as an evidence, he should have shown this to me before so that I can pull my copy of this email. So I'm not going to agree that I sent this to you. I remember having a conversation in reference to this building. Do I remember this email? No, I don't. Does it have my name on it? Yes, it does.
So you're saying that some third party fabricated or I
I
fabricated
didn't say
it?
that. It is possible, but I didn't say that it was fabricated.
Okay. Next question. How many laundry rooms are there in the building?
I don't know, how many do you own in the building?
Madam, I'm not testifying right now.
Oh.
So you don't know how many laundry rooms there are in the building?
I was told that there were 27. I did not count them all. As I stated to you earlier, all of the laundry rooms were locked when I was there, so I wasn't able to count how many
Okay.
laundry rooms there were.
Who locked the laundry rooms?
I don't know.
Who has the key to the laundry rooms?
I don't know.
Who is responsible for maintaining the plumbing and all of the common elements that service the laundry rooms?
The condo association is normally responsible for the common areas, for maintaining the common areas.
And you stated earlier that you're not familiar with the condominium declaration as to that. And you stated earlier that you're not familiar with the condominium documents themselves. So based upon this complaint, you filed a violation of the city ordinance. Let's see here. Charging that a violation of City Ordinance 29-3-212, is that correct?
Yes.
And that's a certificate of use. It says, no structure other than a single-family residence or duplex shall be used or enlarged, or any new use made or enlarged of any land body of water or structure without first obtaining a certificate of use from the Department of Building and Zoning. Is that correct?
That's what it says.
That's the violation?
That's what it says.
Okay. Now, when did statute 29-3-212, let me withdraw that. Do you know whether this building was permitted to be built when it was built? Was it a properly permitted building?
I did not do any research on whether or not the building was properly permitted.
So, do you believe the building was properly permitted, or do you
What's
think?
the relevance of where's this question going? Why is she
Your-
being asked
Your
about when?
your city code specifically exempts anything prior to the enactment of that ordinance. And if you give me a minute, I'll find it. Let's see here. Florida statutes. North Miami, Florida Code of Ordinances, Section 3-101. Purpose and applicability. The purpose of this article is to establish and describe the types of procedures involved in obtaining development approval. This article establishes the requirements for each type of development approval, beginning with general procedures which are applicable to all levels of approval and followed by specific procedures that are applicable to each process. This article is applicable to all applications for development approval that are initiated subsequent to the date of adoption of these LDRs. The LDRs referring to Chapter 29, and this ordinance was passed 4/28/09. My ownership interest preceded that, and the building preceded that. It has everything to do with it. I'll get to that when I testify, Your Honor. But yes, there are laundries. I'm not operating the laundry room. I own the laundry equipment. What I'm trying to elicit here, Your Honor, I mean, I can make my argument
Sir,
to you.
you have to
It's
speak
real
into the
simple.
microphone. Sir,
It's very
sir,
s-
over here. Sir,
I'm
you have to
sorry.
speak into the microphone. We're recording
Oh,
this.
excuse me, I'm sorry. The case is misplaced. This is a 40-year-old building. I've been in possession and operation of the laundry equipment since 1997, prior to the enactment of this ordinance. The building was built with a building permit and is a legal building and a properly operating building. I've been operating this for, what is it, 1897? So what is that, 18 years. So I've been operating this for 18 years. I did this, I actually was involved with the conversion of this. And, I mean, I can go on through some other areas. The building has turned into a mess unrelated to me. I've owned and operated numerous apartment complexes. I've developed, converted, sold, and operated numerous condominiums. The problem with condominiums that turn into rental buildings is that you have a whole bunch of landlords that are absent. You've got 172 units, I think, there. And my understanding is 60 or more percent. So what is that, 70, 80 units, 80, 190, almost 100 units are rental units. Even though they're condominiums and they're owned by a condominium owner, those are absent owners. They're not there all the time. They don't have a resident manager like you would in a regular apartment complex. So as a result, you have chaos. I have had horrific problems with the condominium management there. There's two sides to every story. And the other side of the story is that under Florida law, and I mean, I'm testifying now, you know, we're jumping the whole thing, but I'll try to short circuit this so we don't waste the court's time. Under Florida condominium law, I have no legal right whatsoever to do anything to the common elements of the building, which is everything other than the laundry machine. Everything but the laundry machine must be maintained both by the condominium declaration, which I'm intimately familiar with, and by Florida law, must be maintained and can only be maintained by the condominium association. There were numerous problems with that. Because of the fact that this building has gone from being a conventional condominium, which was, when I was involved with it, was about 80 or 85% owner-occupied units, or second homes, another 10 or 15%, and now it's turned into almost 100 units of rentals. The renters there have been horribly vandalizing the equipment. I have all of my records here. I have the Maytag dealer has from day one, I bought these from the Maytag dealer. They've maintained them from day one. I've spent $2,000 and $3,000 and $4,000 a month more than I took in trying to keep these machines in one piece. In addition to that, the drains wouldn't work, which is the condo association, and they went through a litany of very problematic management They've got decent management in place now, and I'm friendly with them, and they're being cooperative. But the water wouldn't turn on, and they would arbitrarily lock the doors. I don't have the keys to the doors of those buildings. I didn't put any signs up on those doors. And I mean, that's the long and the short of it. The building's been there 40 years, the laundry's been there 40 years, I've been there 18 years. I don't own or control anything to do with the brick and mortar. All I own are some laundry machines, and that's it. And my ownership of that and my operation of that precedes this statute by several years, and this matter should be dismissed, aside from a whole bunch of other technical issues. I also would like to state that I believe that the attitude of this code enforcement officer is very antagonistic, at least towards me. I don't appreciate being threatened with police action. I don't think that's an appropriate method of code enforcement to allude to that in any sort of document. All of the paperwork that I've received, the dates on it, the date of the paperwork and the date of my receipt of the paperwork is anywhere from a week to 10 days later than what these documents are dated. I just had a problem. I had to come up to North Miami and ask for a continuance because I got a notice of a hearing in June. Well, let me back up a minute. When this first occurred, and I have my documents with me, do you want me to testify? Or you want me to cross-examine? Whatever you want me to do, I'll do. Okay, well, let me try to move things along. Let me testify, and then I'd like the opportunity to finish my testimony. But here are... I met with...
1 second. I think my mic was off. Let me repeat what I said. The procedure is that the city will present its case first. If you have any questions for Officer Willis, please ask her so that she can call her first witness, because I do understand one of the owners is here present to testify, and then I will definitely give you an opportunity to cross-examine the city's witness or witnesses. I think there are 2 people here, and then of course you'll get the opportunity to make a final statement, a closing statement, if you wish to do so.
Well, I haven't finished cross-examining this witness.
Okay.
Your Honor, if I could do this quicker, I would. I have to make a record, because if I have to take this up on appeal, I have to have a record to show what I believe are the reasons why I should prevail.
Okay. I'm actually baffled as to why you didn't file an answer and you didn't provide the city attorney with your evidence, with documentations, whatever it is that you wish to have you have introduced in court today. Because surely she wants an opportunity to review what you have and be able to have an answer, at least be able to ask questions of the officer.
With all due respect, I'm not aware that there's a procedure to do that. I have read the City of North Miami documents over and over again. I don't believe that the city has filed any sort of a procedural manual as to what should be done here. I don't believe the Florida statutes do that, and I normally, and I've represented myself and other people in front of other boards, I've never filed a so-called answer in this, because it's a quasi-judicial proceeding.
Okay.
And I normally just examine the officers. I don't normally have this convoluted of a situation, but this one is convoluted, and I believe it has been directed at me in a very personal way and in a very inappropriate way.
Okay. I'm not familiar with your history with the city, so
Okay.
I mean, I hear what you said, but I don't know that
I
I will take that
apologize.
into consideration, because this is the only matter that I have regarding to your, is it Vecino Del Mar Sales
Yes.
Corp? Regarding your corporation, this is the only matter that's before me, so I really don't know your history with the city. And so I will
I have
only
no
take into
history with
account-
this or any other city.
Okay.
I've
No,
been-
you said, I think, I heard you said it's kind of a personal against you,
I
like a
believe the way
vendetta
this has been
against you.
handled, it has been. The other side of the coin is, may I continue?
Sure,
Thank you.
absolutely.
Are you aware of how many other condominiums there are on 135th Street?
I'm not aware of the number, but I do know that there are several other condominiums on Northeast 135th Street.
Is that your territory that you patrol or that you?
No, it isn't.
It's not your primary. Are you familiar with 13499 Biscayne Boulevard?
Yes, I am.
Do they have a certificate of use permit for their laundry rooms?
I don't know.
Are you familiar with Keystone Towers 1, 2125 Northeast 135th Street, and Keystone Towers 2, 2135 Northeast 135th Street,
I am not familiar, no.
whether they have a certificate of use for their laundry
You
rooms?
asked me, was I familiar? I'm not familiar. Do I know if they have laundry rooms? I do not know.
The Dorset House, 2500 Northeast 135th Street.
Okay, let's concentrate on the one that we're here for, and that's at 21 Palm Ave, is that the address?
2350.
2350
2330.
Northeast 135th Street.
Your Honor, I apologize for taking so much time, but I have to make my record. It is against the U.S. Constitution to enforce against just one person or one entity. You can't have selective enforcement because somebody complains that the laundry room is broken and they don't know who broke it or why it was broken. And that's where I stand right
The only
now.
thing is that she answered you and she said this is not her area. So
Okay,
if this
I have-
question is being asked of her and she says this is not her area,
Okay, then I'll
and
testify.
therefore,
Okay, I don't want to offend Your Honor, and I'm trying.
no,
hard-
I'm not offended at
Okay,
all. I'm just,
but I have to make the record if I have to
Okay.
take this up.
all right.
There's another three, Dorset House, Waterside Towers, and Chart House Apartments. Are you familiar with whether they have laundry rooms?
I'm not familiar. No, I'm not.
Do you know if they have a certificate of use?
I have never checked to see if they have a certificate of use at those locations.
Why is that?
I was called out to this property based upon a complaint,
Okay.
and I responded to the complaint.
And how many complaints did you have?
I don't know how many I had that day because you've never asked me this prior to today. So I don't know how many I had, but I do know that I responded to this complaint.
So you had a singular complaint you responded to.
On this building, I actually responded to a complaint that had several issues, the washing machines and the dryers being one of them.
Okay. Now, you've referenced this complaint against Unit 201 in the building. Why is that?
Because that is where the owner, I was told that the owner of the washing machines and the dryers lived inside that unit. I was told that by the management. I know you don't like hearsay, but the management company told me that you were the owner, and so that's why I cited you as the owner.
Okay.
And I think that he provided me the name of the company as well. I think he gave me a lot of information that day.
Okay. I'm going to move, just for the record, I'm going to move to strike as being hearsay. You don't actually know who owns Unit 201, do you? You have personal knowledge of who owns it?
Bear with me just for a second. The owner of 201, it's property address 2350 Northeast 135th Street, Unit 201 is Vecino Del Mar Sales Corp. The mailing address is 21 Palm Avenue, Miami Beach, Florida, 33139, according to Miami-Dade property appraisers.
And are there any laundry facilities in Unit 201?
I've never been inside 201. I cannot give testimony as to what's inside Unit 201.
Do you believe there's laundry room facilities in Unit 201?
I cannot say that I believe that there's one in there. There could be one in there, but I do not know.
You mentioned that you posted the notice of the violation or the notice of the hearing on Unit 201?
Correct, yes.
I thought you sent the notice to 21 Palm Avenue to me, to my company.
Correct, it was.
Why did you post it on Unit 201?
Because I cannot post in Miami Beach, because I don't work in Miami Beach. So any of the addresses that need to be served inside the city of North Miami, if it's my case that's being heard, we post as soon as we get the notices to appear as a form of service.
Are you familiar with the Florida Statute 162 as to the procedure for giving notice of a hearing?
Yes, I am. I cannot state it verbatim, but I am aware of Chapter 162, which is why we sent it certified mail, as well as posting downstairs here at City Hall.
Are you aware there's an Attorney General opinion, AGO 1986-76, that says you're not supposed to post on the door?
No.
Are you aware that there's a tenant in Unit 201?
Bear with me for 1 second. No, I'm not aware that there's a tenant in number 201.
Are you aware that the tenant was very upset and disturbed by the fact that you posted that notice on his
No,
door?
the tenant's never called me. I wouldn't have no knowledge of the tenant being in 201 or the tenant being upset.
All right, is notice an issue as well?
Notice is not an issue, but it's a
Okay,
violation
Mr.
of Florida
Spiegel.
law to post on the door. And in particular, this had nothing to do with the laundry rooms. All it did was upset a third party that is a tenant in that unit.
And that third party's not here to tell us how upset he or she was, so
But-
let's move on.
But I'm here to testify as to what the third party,
Absolutely
did.
not. You know that's hearsay, and you have
Understand.
raised that question, you've raised that numerous times, so
I-
no, you're not allowed to testify
no,
as to what
only
the
the city
tenant
can do
says.
that. I can't. Okay.
No, the city cannot do it either, but we want to move to your next question.
I have nothing further.
All right, do you have any question?
Officer Willis,
Yes,
what department of the city do you currently work for?
I work for the Police Department of City of North Miami, Code Enforcement Unit,
Thank you. And
Minimum Housing Division.
as an employee of the North Miami Police Department, is it usual and customary for police officers, law enforcement personnel to accompany you on inspections and investigations?
Yes, it is.
In this particular situation, would it have been out of character for a police officer or law enforcement officer to accompany you on this investigation?
No, it would not.
What would have been the purpose of their accompanying you?
A couple of different reasons, sometimes to ensure my safety, sometimes just as a witness, because if I'm meeting with several people, I need someone there to kind of substantiate what I'm saying. Sometimes it's a matter of getting access inside the building. They have, I guess, a special way that they actually gain entrance into the buildings. So there's several different reasons why the police would accompany me.
And as a minimum housing officer, is it usual and customary for you to conduct inspections of condominiums as well as multifamily rental housing units?
Yes.
Are you familiar with how laundry facilities work in both scenarios?
Yes, most times, yes.
Under the city's code, is there a difference between a supplied amenity and a business for which a certificate of use would be required?
A supplied amenity is usually something like, say, for example, in the apartment building, that is provided by the apartment owner or maintenance company. They service it, they do everything that needs to be done with that those particular machines. However, anything else that is within other edifices, then usually we would cite, because it's like a business. If you go inside, he mentioned 134.99. If there's a store operating inside the condo building, although there are residential units inside, that particular store needs to have a certificate of use and a business tax receipt. And we do sweeps inside those buildings quite often.
And is it usual and customary for condo associations to be responsible for a supplied amenity as versus a business?
I'm going to object to the form of the question. Is number one, it's leading. Number two, it calls for a conclusion. Number three, this is not an expert in the area of
I'll
condominium
retract the
law.
question and rephrase, Your Honor.
Sure.
Is it usual and customary for supplied amenities to be the responsibility of a condominium association?
I'm going to object that this witness doesn't have the background and is not qualified as an expert to have that information. It would strictly be a guess on her part.
Can you rephrase the question?
Actually, I'll move on. Is it a characteristic of a supplied amenity that it would be free of charge?
Sometimes it's free
I'm
of charge.
going to object to the
sometimes-
question. I'll
I'll
just make
retract, Your
I'll make
Honor.
a continuing objection, Your Honor, to save time. If Your Honor will stipulate, you stipulate. I have a continuing objection.
I'll retract, Your Honor. I'm done with my redirect. Thank you.
All right, call your next witness,
Let me
please.
just, if I may,
Sure.
is there an operating store in this building?
Which building
In
are
the
you-
Vecino Del Mar, is there an operating store in there?
I've never seen a store inside that building, no.
Have you ever seen any people working or operating in the laundry room?
No, I've never seen anyone inside the laundry room.
Are you familiar with the North Miami Code as to why this certificate of use is needed or required?
Yes, I am.
And what would that be?
I would actually need a copy because I know that you're, I would like to watch the way that I answer this question. So there is an ordinance that specifies exactly why you need the certificate of use, but it usually is to ensure that the business that you're stating that you're operating is exactly what it is.
I don't understand the question.
If
what-
you're saying that you're a retail store, you must be selling you are operating and selling retail items. If you are a restaurant, it should not be retail, it should be a restaurant. So
So-
whatever it is that you're applying for, which you've never made application, so I can't say what you have there, but if you were to say, hey, I'm gonna put these washing machines in here and I'm gonna charge, and this is my business because I do generate revenue from this business, it would be expected that you would have a certificate of use as well as a business tax receipt for that business.
Why is that? If the business, as you call it, there's no business if the laundry machines and the laundry rooms were there for 40 years, and I owned those laundry rooms for the past 18 years. Why didn't you come to me 18 years ago and ask me to get a certificate of use?
No, we're, okay. Is this your last question for the code enforcement officer? We have to move on.
Where in the city of North Miami Code, or let me rephrase this. The violation you charged is 3-212, certificate of use. Is that correct?
Bear with me 1 second. It's actually 29-3212.
Okay, but that's the ordinance number.
Correct.
If the use was in existence prior to the enactment of this ordinance, why would a certificate of use be necessary?
All business owners within the city of North Miami, when this ordinance was put in place, were given not only prior notice that this new ordinance was coming into effect, but we sent so much verbiage, documents, pamphlets out to let people know that this ordinance was going to affect its business owners. And so after, there was a date, I don't remember what the date was, but there was a date when it was going to become effective. And after that point, most of the businesses within the city were cited and notified that they needed to apply for the certificate of use. Some business,
What year did you come from Miami Beach to North Miami?
I never said that. I said that I worked at Miami Beach in 1995. I came to the city in 2007.
So you don't know what went on before you came here in 1997 or
All right, Mr.
1998?
Esquigo.
The ordinance is a new ordinance. It's a new ordinance. It wasn't here in 2007 when I started.
Mr.
What year did
Siegel.
Your Honor, I don't know what to do. I mean, she keeps going on and testifying as to things that are really not correct. I mean, I've read your ordinances. I've spent a lot of time to do it. What year did that ordinance, did the certificate of use ordinance come into effect?
All right, so you're asking her questions
She,
and she's answering, and your objection is what?
the answers are unresponsive. She's going on and making other statements. She stated the city sent out a notice when this was done to everybody when it was enacted, but she doesn't know when it was enacted. I'm just trying to pin her down as to what she does know or doesn't know. It's not fair. The notice was sent to everyone. Well, I'm going to put my hand up in a minute and testify I never received or heard about it.
Okay, well, it's your responsibility, sir, and you know that. When a rule, an ordinance, or a statute or a law is enacted, it's your responsibility as a resident to know.
That's correct, unless my building has a certificate of use by virtue of the fact that it was finished 40 years ago, and I've owned the property for 18 years.
Right, are we talking about the property, or are we talking about the business that's
We-
inside the property?
Well, the business has been in the property for 40 years, and
So you're indicating that you've owned those lots, laundry, equipments, where owners pay to wash their clothes for the past 40 years?
for the past 18 years, and I'm familiar with the building, and I'm familiar with all of the documents that were filed and recorded on the building and the condominium documents, which show that this has been there for 40 years.
Okay, so basically, you keep using the word 40 years, but you're also testifying that you have owned the equipment for the past, is it
18
18
years.
years? Okay, so let's stay within the past 18
Okay.
years. So you have been operating the laundromat inside the condominium for the past 18 years. Is that correct?
That's correct.
Okay.
I've been operating the laundry equipment for the past 18 years. Your ordinance that you're traveling under does not contemplate someone having to, with an existing building, having to come in and apply for a certificate of use. The use was in existence prior to your ordinance. Your ordinance does not require any business. It doesn't say that. It says any business anything that is created after the ordinance. Then there's a second ordinance, 3-101, which specifically says that anything in existence prior to this is exempt. That's my whole point. The use of these coin laundries was in existence prior to your ordinance. Your ordinance does not require somebody, when the ordinance came into effect, there's nothing in there, directly or indirectly, that requires an existing use to go out and get a new certificate of use.
May I say something? You may be mistaken.
Ma'am, just please, I don't want to be disrespectful, but I'm proceeding here, and I'm
Okay.
trying to
No problem.
do
I'm
it in a
sorry.
polite fashion.
I'm sorry.
All right, so that was your argument. I'm going to allow the city attorney to respond.
Thank you, Your Honor. On this particular ordinance, there was no language grandfathering in any businesses that were in use. Like most of our ordinances, it has an effective date, and it's effective upon the second reading by the mayor and council. Upon their adoption on the second reading would be the effective date for the ordinance. And in looking at section 3-212, it does go towards the requirement of any business that's located within it says no structure other than a single-family residence or duplex shall be used, enlarged, or any new use made or enlarged without first obtaining a certificate of use. Said CU shall be required for each individual business in each multifamily building located within the city. No person shall use or permit the use of any structure or property hereafter created, erected, changed, converted, enlarged, or moved until a CU reflecting the use, extent, location, transfer of ownership, or other matters related to this section shall be issued to the property owner. There is just no grandfathering language within the section or within the body of the ordinance. It did have an effective date. It would have been upon second reading by mayor and council. In looking at Municode, it indicates that it was first adopted under ordinance number 1284 upon second reading on October 27th of 2009. So any business in the city after that date would have been required to come into the Community Planning and Development Department to apply for the CU. And, you know, as a side issue, all business owners within the city for quite some time have, are required to also, in addition, apply to the city clerk's office for a business tax receipt and pay those fees as well. And I believe it's a testimony of this gentleman that that hasn't been done either.
I'm not familiar with that. I'm not here on that issue. All I've been here on one item, and I'm responding to it.
But that may be why you didn't have prior notice. I do know that some of the promotional literature that Officer Willis spoke of was perhaps marketed to business owners via our listing in the city clerk's office of registered business owners who have a business tax receipt.